Hey everyone, hope you're doing well today. This is Ryan Bradshaw, instructor for business law. And today we're just going to do a introduction to chapter 8, which is on sales contract. I know the last chapter 7 was on contract law. And since this is business law, sales contracts are a big part of that. And so just a few things we're going to go over are basics, American legal principles, sources and types of law, and the importance of business law. And so I'm just going to jump into this and talk about a few things to kind of get you an introduction to the chapter. Once again, not designed to replace the reading. And so when you look at a sales contract, a couple different features to talk about. It says commercial enterprises that engage in buying and selling practices need to be aware of the features and nature of a sales contract. A contract of sale is a specific type of contract in which one party is obligated to deliver and transfer ownership of a good to a second party, who in turn is obligated to pay for that good in money or its equivalent. The party who is obligated to deliver the good is known as the vendor or seller. The party who is obligated to pay for the good is known as the vendee or buyer. It's generally been established there are 6 main features of sales contracts, which are consensual. They are perfected by mere consent, without the need of any additional acts. Bilateral, both parties in the sales contract are bound to fulfill reciprocal obligations toward each other. Onerous, the goods sold is conveyed in consideration of the price, and the price paid is conveyed in consideration of the goods. Communicative, the goods sold is considered to be equivalent to the price and vice versa. I pronounced that incorrectly. It's commutative. I'm sorry, not communicative. I actually do wear my glasses, so that's probably a sign I need to put them back on. There we go. So nominate. This type of contract has a special designation or sale. And then lastly, the principle, the validity does not depend upon the existence of other contracts. So those are just an introduction to the feature. So let's talk about the source of law for contract sales. So in 1952, the UCC, the Uniform Commercial Code, was created to govern business transactions. All 50 states have adopted the code, but each has the power to modify it in line with the wishes of the state legislator. And so, generally speaking, we do have a umbrella law, the UCC, which governs commerce between the states and within the states. And the states can modify that UCC code within reason as long as it doesn't go against the nature of the UCC, which is designed to allow for cross-state line sales and things like that. So the UCC categorizes items that can be bought or sold into 3 types. Goods, these are movable at the time of identification to the contract for sale. Therefore, the primary feature of goods are that they are movable and tangible. Refrigerators, paper, and furniture are all examples of goods. Services are items that are movable but not tangible. Accounting is an example of a service. Realty describe non-good items but are tangible and not movable. Under this definition, commercial and residential property are classified as realty. So a couple different things there. Other points to point out. Items that are attached to realty, like a counter or bar, and that are used for business activities are described as trade fixtures and treated as goods. So if you sell a house with a dishwasher attached, actually installed into the counter, that's a fixture and it's a part of the property now. And so you can't sell the house with that fixture attached, and then before you leave, like remove that fixture and take it somewhere else. At the time of the sale, the new owner had the reasonable assumption that that fixture would be attached and be included in the sale price. So you have to be aware of that. And even though you may have ignorance of some laws, that doesn't mean they don't apply to you. And so now you know, one day when you own a home and there's things that are physically attached to the property, that becomes a fixture. My parents are currently about to sell their home in the next short term, meaning 1 to 5 years. I don't know exactly when that'll happen, but That's something they're actively looking at. And currently they have a shed that's located about 50 feet behind the house and is used for storage and things like that. And if they want to retain that shed as their property, it is movable. They need to go ahead and move it prior to a sale, because if they don't move it and the sale occurs, that's considered a fixture. It's there, and the new owner will say, hey, I bought this land. It's on the land. There you go. It's part of the property. And so a mixed sale, tangible item tied to an intangible item, and pure services. So like, I'm sorry, I missed the beginning of this. So software licenses are not tangible, but they are also not movable and have been treated in different ways as goods, a mixed sale, a tangible item tied to an intangible item, and pure services. Items such as soil and clay may be treated as a good even if they are part of an immovable land, because they can be extracted and moved. Crops that are sold while they are still growing on the land can also be considered goods, even though they are technically immovable while growing. So merchants are classified as a separate entity under the UCC. This distinction is important because the code contains provisions that specifically apply to merchants and place greater duties on merchants to protect private citizens. There are 4 ways in which an entity can be classified as a merchant. So an agent who regularly sells goods as part of his or her business or trade. So if you say I'm going to open up a business, I'm going to go start selling hot dogs in a little hot dog cart on the side of the road, guess what? Now you're a hot dog merchant. You have a duty of care to make sure that the hot dogs you're selling do not make your customer sick or cause harm. And so that classification, you've now been classified as a merchant from the court's perspective. An individual who employs other people to sell goods also adds to that classification. A person who works for a person who sells goods. So if I say I need a job, I want to come sell your hot dogs for you and let you just stay at the house, I become a merchant under that definition. And then any entity who self-identifies as a merchant is also classified. And there's some examples here of the book definition, but I offered that one example there. So the formation of sales contracts under the UCC. So the UCC includes a new category of offer. So the sales contracts require most of the same components under the general contracts, but the UCC includes some provisions that specifically pertain to the creation of sales contracts. So basic contract law states that for an offer to be valid, it has to have definiteness of terms, meaning in the UCC the most of that is particular rule is modified for greater flexibility. If the parties have open terms, the UCC addresses the situation as an overlay of reasonableness. For example, if no time or performance is designated, the performance must occur within a reasonable time. There's a reason that reasonable is in quotations, because what I may deem as reasonable, someone else may not deem it as reasonable. So ultimately, the courts will make a decision on that. So let's talk about a few other things. The only term that cannot be left open is the quantity term, meaning how much of something. The court is not going to second guess a quantity if the parties don't set one in the contract. For example, why would the court arbitrarily want to force the parties to buy and sell 15,000 widgets if a quantity wasn't specified? Excuse me. There are 2 exceptions to this rule: requirements contract, as much as I need, and outputs contract, as much as you can produce. Even though these ideas are illusory, they're generally allowed in commercial setting with good faith limitations under the UCC. Let's see, under the section 2-205 of the UCC, offers made by merchants are considered to be firm offers if the offers are made in writing and explicitly states that there is a 3-month irrevocability period. A 3-month irrevocability period is assumed if no mention is made with the offer. Acceptance of the offer can be made in any reasonable manner, but the mirror image rule does not apply under the UCC. This means that if the terms of the acceptance do not mirror those of the offer, the acceptance is treated as a counteroffer and no legal contract is formed. Sales of goods contract must be in writing if the value is over $500. Modifications to the contract must be made in good faith. New consideration is not required. A contract provision or the entire contract itself can be considered unconscionable if the terms are unfair or unreasonable. So there's this term that you see over and over again, reasonable. And so what is reasonable? In a criminal proceeding, if you have a reasonable doubt that the person did not commit the crime, then you're supposed to exonerate that person. Because if you look at it honestly, in a lot of cases of criminal law, we don't know certainty. Like, even if you look at very compelling cases where you feel very certain that this person did this thing because all the evidence indicates as such, but unless you were there and you witnessed the crime with your own eyes, how can you really be certain? You're actually just using educational deduction and critical thinking to say A plus B equals C, right? If this person was at this place and time with this opportunity and motive, and this thing happens, you reasonably deduce this person probably maybe had something to do with it. And so reasonability or reasonable, that's something you see often in law. And so let's talk about title. Title means the ownership of a good. When the sale is completed, an agent must pass the title for the good to the buyer. There are 3 types of titles. A good title describes a title that is obtained from an individual who owns the goods free and clear. Void title occurs when the title is passed to the buyer from a person who does not legitimately own the title. And then voidable title occurs when the contract would have been good, but certain circumstances makes it voidable. For example, if the buyer was deceitful about his or her true identity, the buyer is a minor, or the buyer wrote a bad check in the state, then the title is deemed voidable. So there's a lot of issues that are associated with titles. I'm not going to go over these. I expect you to read these and the section on international goods. I do want to talk about warranties real quick. And so what are warranties? A warranty is a guarantee, right? A warranty is a guarantee on the good that comes as part of the sale of a contract. But contract law treats warranties as an additional form of contract that binds the selling party to undertake a certain action. Typically, the selling party has an obligation to provide a product that achieves a specific task, or to deliver a service that meets a certain minimal standards. So the example that pops in my head when I talk about warranties, I bought my oldest child a toy for Christmas probably 7-8 years ago now, something like that. And on the box, it's got a warranty, that it states if anything happens, it's under warranty. Just contact the manufacturer. Don't call the store. Don't take it back to the store. Just let us know. And so something happened within the first couple of weeks. It wasn't holding a charge. It's a problem. So I contacted the manufacturer about the warranty, and they never honored the warranty, basically. And so basically what the manufacturer was gambling was that would I take them to court over this issue? Because that's my only recourse. If they're not going to honor the warranty, my recourse is court. But of course, I'm not going to spend, the item was about $100. I'm not going to spend hundreds of dollars, if not thousands of dollars, on a court case. Now, if I was a wealthy person and I just wanted to make a point, I might have done that, but I did not. So, all right. I want you to continue to read about warranties, what happens if there's a breach of warranty, and go through the rest of the chapter. This was meant to be just an introduction to contracts dealing with sales. If you do have any questions, please let me know. And I hope you guys have a great rest of your week. Thanks, guys. Talk to you soon.